In the Brian Kohberger case, his defense is so angry with the prosecution and their failure to comply with discovery, they're now asking the court to take the death penalty off the table.
I'm really confused. This judge is confused about his own powers in the court and what he can do and what he can't do, which is just baffling to me.
He's confusing me and the families, I'm sure, about what he has the power to do.
And this case was already so divisive. Things are just getting infinitely worse. There's been a lot of confusion going on. What's in the judge's powers? I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have our wonderful guest, Forensic Frenzy. How are you doing today?
Great, guys. How are you?
Doing good. And we also have the wonderful, amazing Yoli Medina. Not that Forensic isn't wonderful and amazing. We love you both. But Yoli, how are you doing today?
Hi, thank you.
Awesome. So there has been some updates. So we had a hearing, was it on May 30th, that people are freaking out about. It has been a complete mess. And we're coming here for a little bit of clarity.
Well, and also before we get into that, and we are going to jump right into the hearing, and we can stop at any time, and any of our panel members are invited to comment on it. But before we do, just before we started to record this podcast, I got an email from Steven Goncalves, and we'll take a look at that in just a couple of minutes. But a hearing was held on May 30th. It was a hearing on a motion to compel. Ann Taylor's got 2 outstanding requests for discovery. And I should say she has 2 motions to compel that are outstanding. And there was a hearing on May 23rd with Lawrence Mowry of the police department. And then on May 30th, the number 1 witness was Detective Brett Payne. We remember that name because he is the author, supposedly, of the probable cause affidavit. And Taylor pushed him on what evidence was used in affidavits to subpoena records, such as the AT&T records. He claimed there were a number of videos, including one from the surveillance cameras at a Red Star coffee shop on Pullman Road. But rather than having produced it, he pushed back, claiming it was up to Kohberger's defense to do the legwork to get it from the police evidence room.
Am I correct in believing that the Red Star surveillance video was collected and given to Moscow Police Department?
It reads that way, yes, ma'am.
Where is it?
I do not know.
Who do I ask where it is?
That would be through the evidence custodian and MPD. That'd be my best direction for you.
So I need to go to the evidence custodian and ask him to bring all of the videos out so I can watch them all to see if that one exists.
Yes, ma'am.
How many hours of videotape do you think have been collected?
A lot.
Thousands?
Yes, easily.
Wait a minute. When there's a case like this where there's a criminal case and discovery requests are sent out, it is the prosecutor's obligation to produce that material. The defense attorney, Ann Taylor, shouldn't be sent on a wild goose chase. I mean, I can just imagine her playing voice tag forever with the evidence room panel. Am I off base?
No, you're not. And you're not off base. And I'm just
going to comment that if there's thousands of hours of video left, then that's what is the 52 terabytes? There you go.
Yeah.
right. So it's the prosecutor's obligation to provide this information to the defense. And we have the lead investigator saying that he doesn't know where the Red Star video is. Now, I don't know what is depicted in that video, but certainly it must be relevant if she's asking for it. So I'm just baffled. How can a lead detective say, I don't know where it is in a case like this?
So based off other locations that they've mentioned, what's supposed to be in that video is either the vehicle stopped and someone got out, which I doubt, or the vehicle just simply passing. And it would correspond with her stating that 3 minutes down the road at Floyd's cannabis shop, the vehicle had also passed, and she said that wasn't her client's car. So she wants that video because she's saying that car isn't my client's car, right? But She doesn't know where it is. And they're like, well, get it out of evidence.
It's
So-
somewhere.
But he doesn't know where it is. So is it in evidence for her to get it out of evidence? However, he is also saying, if it is there, that she's welcome to come down and get it, and he will help expedite such. But
Yeah, but
he
she
also
shouldn't
said he doesn't know what's there. So
She shouldn't even
maybe
have
it's
to
not.
do that. I mean, if she has sent out discovery requests and she's requested that video or videos of a category within which that video fits, she shouldn't have to go over there. She shouldn't have to play telephone tag with whoever runs the evidence room or, make an appointment. No, it's not her obligation to go over there to the police station and sit around and wait while they hem and haw and take their phone calls. No, it's the prosecution's obligation to get it and send it to her. I'm sorry.
Especially looking for something that they are saying, we don't know if it's there, but if it is, that's where it would be. Right.
Right. That's right. And it's like she is, and I mean, I practice civil, but I'm sure it's the same. She's basically, Ann Taylor is basically interacting with potential witnesses and trying to get this information and completely bypassing the prosecutor. I mean, it should be through the prosecutor. That's how I understand it, but maybe Idaho and criminal law is different, but I have no idea. I'm just really confused.
Well, I do some criminal. I used to do a lot more than I do now, but when I'm involved in a case, I deal with the prosecutor. I deal with the attorney. In fact, you almost touched on something there. I think it's almost a conflict of interest for me to start calling the police officers themselves and talking to the police officers themselves. I send a discovery request. Most of the people that I've dealt with on the other side, they send you the Brady material right away. In fact, you go into the arraignment and they hand you a discovery package or they send it to you right away. And if I have additional materials that I want, suppose a certification of an OUI machine or suppose the record of an officer or something like that, I send out a discovery request to the prosecutor, the attorney, and then they get that material and send it to me. No, I don't have to go to the police station and knock on the door and sit there while they're finishing their coffee and having them scarf up this. That's wrong. I'm sorry. It's crazy.
And you said something that kind of built my train of thought where it's like they'll give you the Brady material right away. And I was under the impression, obviously, I'm not a legal professional, but I was under the impression that if the prosecution is going to be using any type of evidence, that the defense has to approve of it and has to be aware of it. So you would think that interaction and exchange would happen at that moment. But like you mentioned, the Brady material being handed to you first, I'm wondering if now it's like, oh, well, where is this video? Who has this video? Why does nobody have this video? It's almost sounding like they're not going to be using that in the case, which means that it could be something exculpatory, in my opinion.
Okay.
I agree.
The next
And
witness,
I think,
I'm sorry, go ahead.
Sorry, I just wanted to interact with that. I agree. And I think that the things that they are holding back today, I noted that there are various videos heading down 95 going south from different places, Mundy's machine and a coffee shop, some apartment buildings. None of those picked up his car. That is exculpatory because that's the route that they alleged he took. And those are a part of what they're not giving her. So when it comes to the Red Star coffee shop, I believe that they gave her Floyd's cannabis because the vehicle is better seen there. They won't give her Red Star coffee shop because it's not. And that also could be exculpatory. You don't know what car it is. So I think they're giving her what they think that is in their favor. And anything that they think she might be able to utilize, they are actually holding back from her.
Well, that's a problem. I mean, if she asked for all videos, they should give her all videos. It's not for them to comb through and I think we'll give her this, but we're going to hold. No, that's
Cherry
not.
picking. Yeah.
Thank you. The next witness was defense expert Cy Ray. We've all heard about him reviewing the cell detail records or CDLs and other data. He claims a great deal of data was missing from that which has been produced. He claims that the Moscow Police Department only mapped a small amount of the data, about 6%. He claims the FBI mapped only 18%. And from what Cy Ray said on the stand that he's seen, and although if the prosecution would provide all of the data, it could go either way. But Cy Ray said on the stand that he has seen a lot, and what he has seen is exculpatory.
Everything that I've seen to date is concerning to me because it's exculpatory. And I need to clarify this. When all of the records are produced and the dust settles and I have time to review it, I reserve the right to say, no, now I'm seeing everything. Here's what I'm seeing. Because of the piecemealing of the data, because of the missing data, because of data that I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in the benefit of the defense right now. There's other reports that I believe are missing that I can't tell you are in the benefit of Mr. Kohberger or in the benefit of the state.
Well, what I thought was interesting is that Cy Ray also said that he said it was a very bad practice to base probable cause on the limited data that has been made available. And I think what he is trying to say is that, they did a probable cause affidavit. And then he also pointed out that they did a ton of affidavits in order to get those subpoenas that Forensic, you did a couple of episodes, going through them all, and what was significant about the fact that they just sent those out. How could a court, he's saying, arrive at probable cause when the affidavits didn't have all the facts?
And well, if I could speak to that, it is an interesting point because judges don't always know when they're signing off on, warrants and things like that, or signing off for arrest warrants, signing off for, whatever. They don't always know the technology that's involved. It could be something like here where they say there's, like cell phone pings and all of that. The judge is not an expert in that. So he's going to rely on the sworn affidavit of the police officer who is alleging or stating in the affidavit that they did this is the result, and we got pings, we got this, we got that. Because sometimes, these judges are asleep and they come and they want an arrest warrant. They're like, or they're somewhere, I have a friend who's a judge and that happens. And you have to just make sure that you can't at that moment when you're going to sign an arrest warrant, question all of the technology that was used in order to arrive at the conclusion. But at the same time, whenever judges hear DNA, even if it's touch DNA, it has some meaning to it. And so I'm wondering when it came to the affidavits, especially in Pennsylvania, because I believe Pennsylvania has an added something additional to probable cause that Idaho does not have. And so when they put in all this information that sounds legit and the judge signs off on it, at some point it's up to the defense counsel to challenge it. And that's what she's doing. That's what Ann Taylor is doing. Now, I don't understand all the technology. I'm sure Forensic Frenzy might understand it more, and Andrew and even Laney. But Laney probably more. But that's the issue when it comes to, these judges signing off on these warrants. And so if everything falls apart, if what is in the probable cause affidavit falls apart, and it's not proven, or not even part of it is proven, why is he in jail?
I do want to kind of build off of that, Yoli, because you did say that in a way that kind of reframed the way that I'm thinking about this, because it's like with the 52 terabytes and the CAS data and the log files and all these different terminologies and stuff, you have a good point where we don't really know the judge's background on this. Obviously we all have phones and computers now, but a lot of these aspects are almost like a different language. So it's almost like we're seeing like the unraveling of like his attitude shifting as he's realizing like what's going on, like why don't are these actual things that's like wrong almost, in my opinion. I don't know.
I thought that Cy Ray's testimony was very interesting overall, because he did say that everything that he has seen so far is exculpatory for Brian Kohberger, which is a complete 180 from what we've heard from Anne. She has said various times that everything that is exculpatory, they have refused to give her. But apparently when it comes to the cast, they've given her everything that is exculpatory and nothing that shows anything else. And then I also thought that it was very interesting. I suppose that maybe he's saying, in my experience, there should be up to 75% more information here. But if you don't know what you've been given, I'm not sure how you provide a numerical value to what you have. If you don't know what you haven't been given, I'm sorry, then I don't know how you provide a numerical value to what you have. So when he says, well, the cops looked over 6% and then this person looked over 18%, how do you know that when you don't know what 100% is because you don't have it? It's interesting that you provide numerical value to things. And I mean, this is just the way that I think. So I did very much think that he provided very clear and concise testimony. I don't know how convincing. And I'd like to think of myself as a person of normal standard logic. And I just don't, that didn't make any sense to me. The math on it didn't math. If you don't know what 100% is, how do you find X? So
my guess
I was
is
very, very confused.
you've made your point, and that's a good point. But my guess is, and I don't know, my guess is that there's some kind of an overall log, but the actual data that was presented to him is only the 6% of the 18%. But there's some kind of an overall matrix that tells him that here's the information that is available, but this is only the thumbnails, the equivalent of thumbnails, and the only actual videos that they gave him were 6 or 18%. That's my guess. I don't know, because I would think that a guy like that would not want to be I mean, if you're right, that's a horrible point for him when cross-examination come trial, when this case goes to trial. But I'm guessing, I'm going to give him the benefit of the doubt. I don't know the guy, and I know that contrary to what a lot of people out there think, judges have gone both ways on him. And so, and I know that, yes, commenters. Yes, I'm very well aware that he has his own social media channel. Yes, I'm very well aware of what people say about him. But the courts have, in fact, federal courts have gone both ways on him. So I wouldn't think that he'd want to be saying things on the stand under oath that are providing grist for the mill for cross-examination. I might be wrong, but that's how I see it.
I think you made a good point with him, theoretically being familiar with the information, being able to identify that the amount of information he has is very small in comparison to what's actually the source. And another kind of train of thought that I had, him saying that everything he has is exculpatory versus and saying that she doesn't have the exculpatory information. It almost makes me wonder if he's seeing it and being like, well, this doesn't say that he was there at all, which he's interpreting as exculpatory, but she still feels like there's a nail in the coffin somewhere that she hasn't gotten, was kind of my interpretation.
So we're going to get into it. I'm sorry. Yoli, we're going to get into an area that you had mentioned earlier. Remember that people are jumping on this, as you had pointed out earlier, Forensic, that this is a motion to compel, a hearing on a motion to compel. This isn't the trial. It's not time to get into the nitty-gritty of the case itself. This was a motion to compel evidence which has not been forthcoming. Co-defense attorney Alyssa Masaf argued to Judge that there's just so much discovery that's missing that sanctions should be imposed on the prosecution. And she got what I saw as a surprising answer from the judge.
You have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear, produce it or it's not coming in. That's the first level of sanction. And then we can just get going from there. Something that's destroyed, you can't produce that. There's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You have control to get these issues that we're struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think
I
I
can't
think you're
control everything.
underestimating your power.
Well, I have a good sense of where my power starts and ends.
Wow. What do you all think of that interchange?
Oh, I have something to say about that.
Please do.
He, you know, if he doesn't understand that he has the power to exclude evidence before trial that hasn't been produced in discovery, if he doesn't understand that he has that power, then I don't know what he's doing there, honestly. You know, where his power starts and ends should not be with Bill Thompson. Where his power starts and ends should not be with the Moscow Police Department. It should be where the law is, what the law says, and what he is able to do. For some reason, this judge thinks he possibly thinks that he doesn't have the power to exclude evidence. He's giving
That's his job.
well, what do you think the judge does when they're sitting at the bench when trials coming in and people object? They'll object, you know, and he says sustained or overruled. What do you think that's about?
I
mean,
object. I know. Does my
I don't
power
have the
start
power
in there?
that's ridiculous. When I
He
heard
signs
that, I
off
was
on
on
suppressions
fire.
and striking motions, and that's his thing.
Yeah, he
I-
can strike
I-
testimony.
I do wonder if maybe he was prompted to say that because she assumed that he could just take the death penalty off the table, like as if it's just only his choice. But he's very confusing. If that is what he meant, if it was the latter that caused him to say that and not the former, then he really should have provided some clarity to make sure that he was providing clarity, not just for us, but because the families are now, you know, they've heard that and they have to go back and forth with themselves about whether or not he knows what he's doing or what he can do.
Well,
Right.
yeah, that was my big takeaway from this whole thing was that Kohberger's attorneys, Alyssa Masaf, are now saying, look, if we don't get the discovery, we want you as a sanction to take the death penalty off the table. And we probably all know, but I don't know if our viewers all know that that's exactly what happened in Idaho in the Laurie Vallow case when the prosecution didn't come forward with all of the evidence. They took the death penalty off the table. And so that was not a death penalty case in Laurie Vallow's case. So there's precedent for that. Switching gears just a little teeny tiny bit and to give Judge, I always have a hard time saying that Judge. But anyhow,
JJ.
It's weird.
giving him the benefit of the doubt, I'm thinking, you know, that he's constantly thinking, or rightly so, wrongfully so, I don't know, about the potential for appeal. And that's the only meaning I could ascribe to those words that, you know, he didn't necessarily his exact words were where my power starts and ends, because previously on previous issues in this case, he has said, you know, we want to only try this case once and get it right. So I can only guess that is what he meant, is that, you know, he can only do so much before there's the threat of, you know, being overturned. And no, Yola, you said you know a judge. I've known some judges also, and they live under the constant, I'm not going to say threat, but the sword of Damocles hanging over their heads that, you know, if they get something wrong, you know, their name goes on that appellate decision that there was judicial error.
Yeah, but if I'm not mistaken, I believe death penalty cases get an automatic appeal.
Oh, yeah.
So
Absolutely.
if a judge is ruling on a death penalty case, he has to know there's going to be an automatic appeal. Okay, if he doesn't know that, then that's maybe he's
well, no, not that I wasn't alluding that he wouldn't have an appeal, but whether the appeal would be successful. He doesn't want to do anything that is finds a judicial error in the record in an appeal. I mean, obviously he knows that there's going to be an appeal in this case. There's no question. My other takeaway was what the attorney had said about a spoliation order. I don't know if our viewers, many of them are really bright and probably do know, but I don't know if they know what a spoliation order is. And spoliation orders go in different directions in different jurisdictions. They can be as simple as, if you, Mr. Prosecutor, do not come up with this evidence, you may not present it at trial. That's piece number one. But piece number two is even more devastating than that. And that is, Mr. and Mrs. Prosecutor, if you do not present this evidence in discovery, I'm going to enter an order that not only can you not use that evidence, but you may not even mention that fact or that issue at the time of trial. And that can be devastating. That can be really devastating. It's more devastating in the context, and you've probably run into this in your practice. I don't know. We haven't talked about this, but I mean, in a complicated products liability case or a med mal case, which you know a lot more about than I do, if there is a problem that the defense attorneys don't come up with some evidence, and the court says, not only can you not use that evidence at trial, you can't even talk about that issue, that can really blow away a part of the case. And so
Well,
I thought that argument by Alyssa Masath was really very important, and I was surprised the judge just kind of blew it off.
yeah. Well, in California, there's a jury instruction that says if the defense has the ability to produce better evidence and they don't, then the presumption is that evidence is unfavorable to that party.
Mhm.
So that's actually jury instruction. So
Wow.
yeah, it's actually jury instruction. So it does they can comment on it, but where is it? If it's not produced, then there's a presumption, and the jury instruction says presumption that the evidence is not in the favor of the party, because they have the ability to produce it. It's gone, destroyed, and there's actually a presumption. So I don't know how other states are, but that's how it works here.
So here's my question to the panel, and that is, again, let's put this whole thing in context. This was a hearing on a motion to compel evidence. And part of a motion to compel is, in my experience, either you produce the stuff, item 1, 2, 3, 4, 5, by such and such a date, or there are going to be sanctions, and that the judge seemed rather reluctant to even discuss that. I'm wondering, what do we think about the possibility that there's even going to be a motion to compel, an order to compel evidence?
Yeah, I'm speechless.
That's a good point.
So as for the IGG, I do believe that we got an order to compel that at one point, right? I think that was the only one we've gotten so far out of all of her many motions to compel. So I don't know if we'll see an order to compel. But I do want to go back to spoliation real quick.
Okay.
I just want to mention the judge was unmoved when she mentioned that. And I do wonder if the reason why is because the things that they're not turning over, they don't plan on using. So it really doesn't matter to them if they can or cannot. So maybe Elisa's not really realizing that doesn't matter to them because they don't want to use those things. They don't want them to come in. So the punishment can't be, it doesn't come in if I don't want it to. That goes in my favor.
Well, but what about Yoli's argument that in her jurisdiction, there's a rule that, the presumption can be added in if you don't produce this stuff. You can't even, the presumption is going to go the other way. There are other, I only kind of briefly looked at spoliation orders in law and procedure. The court can do a lot. If you have a more activist court, I guess I don't know if that's
so. Here's my example.
Yeah.
The Red Star Coffee Company. Yeah. She's gotten Floyd's cannabis shop. Mm-hmm. They can use that. It's better imaging. Might look like his car, right? But say Red Star Coffee Company doesn't. They don't want that to come in then, right? Because did you lose the car? Is that the same car? If the quality of the imaging changes, you see what I'm trying to say?
Yeah, but that turns the whole thing into kind of a game of chess. Okay, we're not going to give you this because we don't want to. They have to.
I'm not saying that they're not doing that. I'm absolutely open to the idea that could be what's going on there.
Yeah.
So the best example I can give in my kind of practice is when you have a mother giving birth, there should be fetal monitor strips. Those are monitoring the baby. There should be there. But when the fetal monitor strips are missing, And that's something that should be there in the record. It's not something that may or may not be. And they're missing. There's a presumption that those fetal monitor strips were probably showed the baby doing bad, and the hospital doesn't want those out. They're lost. But nowadays, they're electronic. So even if the electronic data is lost, the same rule applies. I mean, there should be fetal monitor strips. There's not. They're saying you can't prove the case because there's no fetal monitor strips. And we're saying, guess what? You have the ability to produce better evidence and you don't have it. Something that you were supposed to have and you don't have it. So the presumption in the jury instruction says if the party has the ability to produce better evidence, stronger evidence, or the actual evidence, and they don't because of spoliation of evidence for whatever reason, whether it's lost, wasn't because the custodian didn't take care of whatever, then the presumption is that it was bad for the defense, in this case for the hospital. So that's how it works here. Now, I'm not too familiar with the technology and what's supposed to be there, what isn't, but I'm sure that it would apply kind of the same way. Like if something's supposed to be there and it's not,
Nope, I totally understand and I agree. I'm just saying that because 3 minutes down the road they gave her that footage.
Right.
I don't think it would matter if it goes in her benefit that 3 minutes further down the road they didn't. And that's what I'm saying is I understand it would go in her benefit, but I just don't know if that would help her any if 3 minutes before that they gave her the footage and the car looks like it could be his. So I see why they would play chess with that specific piece. That's all I'm saying.
How about this? How about this?
Seem like it makes or breaks anything.
If I were a judge, here's what I'd say. Of course, I'm not a judge. I always sided with the wrong guy. But anyhow, if I'm the judge, I'm saying, listen, if you don't give all of the video to Kohberger, we're not letting any of the video in. Why not? Why not?
Well, that has to be the case because you can't have them producing stuff. Oh, the day before trial. Oh, we found the video. We found it.
No.
And they also
Attorney.
have given her videos that it doesn't appear really make that much sense. So the ones that she wants that are missing from down Highway 95 South, Mundy's Machine, the coffee shop, the apartments, they said that they actually have given those to her. And then she made the point that, okay, but you gave them to me and they're from 5 a.m. to 6 a.m., which is irrelevant because at 5:30, you're assuming that that person was back over at WSU. So how does that help me? I need the video footage from those places at the time that he would have been in those places. So even in the instance that they're giving her stuff, what she's saying is you're giving it to me in time slots that really don't pertain to whatever vehicle you say you're chasing down that would have been in that area at that time.
Interesting. So speaking of Yola, you were talking about, I found something the day before trial. Speaking of Prosecutor William Thompson, wasn't he quiet during the hearing on May 30th? Wasn't that interesting? Why do we think he was so quiet?
And his face was so red.
He's the guy that's been saying, we gave him everything. Oh, wait, no. Oh, we gave him 95% of everything. Oh, we've gone through our files. We've given him everything. Oh, oops, on May 23rd. Oops, we did it again. And it came out through Detective Mowry that the prosecutor's office only called the police department the day before the hearing. So while Mr. Thompson all along is saying, we've given them everything, they didn't even look for it. So
see, that's bad faith. To me, that's bad faith. Because if you have an obligation to turn over everything, that means the prosecutor has to ask people for it. They have to ask and get the information. They have to get the information. And that's why the judge did that order that everything from the FBI is within their control, because the prosecution can just go and get it, ask for it at least, but if they're not asking for it and just saying, we don't have it. Well, to me, in my opinion, that's bad faith. And that's something that could be subject to sanctions, but I don't know what this judge is thinking.
I agree with you.
Go ahead, Lainey.
No, that's I just completely agree with Yoli. I don't have much more to add to it. Just that you're totally right. Where if they're not even asking people for it, then you're not really putting in any effort to actually make sure you have everything. And especially where if you have any of the video evidence whatsoever from, like they said, they got to go talk to people and evidence, whatever. they should have had that. So if they lost any of that footage that they had seemingly already combed through, then that's mishandling. It's like, if you had it, then you should be handing it over.
So
And Elisa mentioned destroyed.
yeah. So William Thompson apparently benched himself and sent Ashley Jennings up to the mound and up to the plate, I should say, to see if she could hit the ball. And so there were 3 strikes. 1, we've produced everything. 2, we can't produce what we don't have. But she came up with a new one that William Thompson hadn't thought of. And the new one, do you guys agree with me? My jaw just dropped. The new one was that, oops, somebody at the FBI is out on maternity leave.
Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns.
Wait a minute. You mean to tell me the entire FBI shuts down because one person is out on leave?
She was running everything.
Yeah, that is insane.
When she's on leave, there's actually no replacement. She's that essential that they can't actually have anybody fill in. It's just the responsibility is just.
And the length of a maternity leave and the amount of time that a woman knows that she needs to find someone to handle her business, when she goes on maternity leave, it's so crazy to think that for an entire maternity leave, this department is just
most corporations have an internal policy. And I don't specifically know about the FBI, but being a government agency with 100,000 million employees, to just refill the coffee dispenser, they've got to have the same idea that most corporations do, that if someone is going out on a leave, someone else is designated to take over all of her files. Here, Yola, you take over file 1 and 2. Forensic, you take over file 3 and 4, and Lainey, you take over file 5 and 6, and so I can now leave and go fishing while you guys do all the work.
They didn't have a system in place.
But you said it more eloquently than I did. There's got to be a system when somebody goes out on leave. I mean, so I don't believe that any more than the first 2 excuses that we've produced everything, or we can't find it, or the dog ate my homework. I mean, so I thought that was pretty weak. I thought that was really, really, really very weak.
As did I.
So my final issue is that in the hearing of May 23rd, Detective Mowry was questioned more and more. It became clear to me, and Forensic, you might disagree with me, but it became clear to me that the prosecutor hadn't even put in requests to the other law enforcement for certain discovery materials until the day before the hearing. So my issue is, has anything been done to clarify the state's discovery obligations going forward?
I say no. I say that this judge is unsure about what he can do and what he can't do, and he's trying to be fair in his mind, and he's trying to say, well, there's a lot of stuff, and and so I don't think much has been clarified, and I think that they're relying on this September date of turning over discovery, and they still think they have time. And
am I correct?
I'm sorry, go ahead.
Oh, and the judge, they still have time, so the judge can't sanction him because he put that date for September. But meanwhile, you have BK in jail. So,
well, the September discovery deadline, which you correctly pointed out, that's a final deadline. Don't forget, when these original discovery requests were put in, those many months ago, under Idaho Rule 16, the material has to be provided, I'm almost certain, within 14 days. In my jurisdiction, it's 30 days, but in the Idaho Rule 16, I believe it's 14 days. So no, it's not a matter of waiting until September. It's a matter of, why didn't they do it before? And maybe through this motion, maybe we'll give you another 30 days, but no, 3 months, September, I don't know.
And
this whole thing to me, sorry.
And prior to the alibi, If you remember, on March 31st, they were supposed to have the cast information in. They were supposed to review it and get it over to Anne. And as of yesterday's hearing, Anne did make it very clear that she still doesn't have the stuff she was supposed to get for March 31st. So
That's crazy.
Even though she was able to frame it in a way that benefits the defense team and that all of this kind of moves forward with the idea that they're not getting what they're supposed to be doing and that the prosecution is not necessarily pulling all the strings that they should be. I really would be surprised if anything changes. I don't know. That's just what I'm thinking, because even though she's able to make all these points, we're still seeing that nothing's being done. He's still kind of moving the blame. It's just like, I know where my power starts and ends. That doesn't really do anything for the future of this case.
Yeah, I've never had a judge tell me, I don't know where my power starts and ends. Usually the judges are telling me, I have the power to do X, Y, and Z to you, Attorney Myers. And then unless you come up, we'll be nice and give you another 30 days. But unless you do, your evidence isn't going in at trial. I've been told that, not in those exact words, but I mean, the judges I've been before are very certain as to what their powers are. And again, the only way I can read those words are, one, it's unspeakable. Number two, that he is very concerned about being, not that there will be an appeal, because there will be an appeal, but because he's very concerned of making sure that the record is as close to perfect as possible so they don't have to try the case again. That's the only meaning I can ascribe to those words.
I do at least hope that he is at least on the surface, because it may not, come from a place of depth, but at least hopefully on the surface, he is aware of how impactful he can actually be on this case. Hopefully he does at least know that he has power.
I don't know. With the whole, I know you're saying that he's trying to, this is towards Andrew's, like, clear everything and to, try to make the record as clear as possible in case when the appeal inevitably happens. But I'm not a legal professional. This just makes it almost seem like the appeal is going to be even more messy at this point.
Well, anyhow, after the hearing that we're talking about here, Steven Goncalves, Kelly's father, of course, wrote a letter, and it was in some of the newspapers. And I saw that letter. Obviously he's not happy with the way things are going. He thinks things should speed up a little bit. And I emailed Steve Goncalves and invited him to come on and then participate in our discussion and say whatever he wanted to say about it. And he actually got back to me and sent me a very interesting email. Here's my email I got back just before we started recording this episode today from Steve Goncalves to me. I'll be tied up here at the hospital working while doing this casework on the side. I am writing a review of Q&A for yesterday's court hearing to help the families gain a better understanding of where the case is at. Lots of moving parts. And in the case of digital cell reports, and this is the part I found really interesting, I understand these technical issues better than the prosecution team does. So we have a lot of input and questions for them. I won't be able to make your interview, but keep up the good work, and thank you for keeping all the parties accountable. So he is an IT guy. I've talked to him before, and he's an IT guy. That's what he does for work, and he's very smart about technical stuff. So he's telling people that he understands the technical issues better than the prosecution team does. So he's going to have input and questions for them. Panel,
Wow.
Your thoughts?
It has to be malleable for the jury to understand. You know what I mean? If it's going to go to a trial, they have to be able to understand it, like, just move them, all the moving parts. They have to make it as simple as possible. And I'm curious. I want to know more. I want to know more about what Mr. Goncalves knows. I want to know more about what Cyree knows, I have to seriously, I would have to listen to his testimony a couple of times because, I'm not a tech person, but I'm very interested in hearing more.
I definitely.
Oh, I'm sorry. Go ahead, Lily.
Oh, I'm so sorry, Forensic. I was just going to say that I agree with that point. I pointed out earlier, how Yoli was mentioning, is just like, well, we don't know how necessarily tech savvy anyone in this case is, anybody's background. The people in this case are legal professionals or non-technology professionals, and even to people who work with tech, there's still a million things that are confusing. So I think that it makes sense. I think it's understandable. I think even when I'm listening to a lot of the time I'm like, wait a minute. So I can definitely see where those questions are coming from.
Forensic closing
I think
thoughts.
that the victim's dad, being an IT guy, Kaylee's dad being an IT guy, is helpful to the other families. It's helpful to himself. I don't know how helpful that is for the story of the prosecution if it's falling apart, or how helpful that would be for whatever story the defense is going to put forth, because he's going to be able to understand a lot more than the average person. I would be interested to know what his questions for the prosecution team are, since he is an IT person and he, believes that he has questions. I'd love to know what they are.
I would too, and I'm going to follow up. I'm going to email him back. I just got that email before we came on here. I'm going to email him back, and hopefully he will share that material with us, and that'll be interesting to hear what the prosecution's response is. I mean, they certainly have no obligation to respond to him, not in a legal sense, but in a moral and ethical sense. We were talking earlier about how frustrating this whole thing is for the families. And so, they should communicate with him, and, who knows, maybe he will open their eyes. I mean, maybe he will bring some technical expertise that, helps them view this case a little bit differently. Who knows? Okay. Closing thoughts before we move on.
Thank you guys so much for watching up until this point. We really appreciate everybody. Like, comment, and subscribe. There's definitely, especially with the Sire, I'm interested in seeing what people have to say in the comments. So
Yep.
All right. Thank you guys so much for joining us today, Yoli and Forensic.
Thank you for having me.
I was going to say,
again, very nice to meet you, Yoli.
Yes, it's nice to meet you, Forensic.
and I want to tell everybody that the day we're recording this, Forensic did her own episode that goes much more into depth. We don't always agree, but she did a really good analytical job with respect to the videos that are available. So I'll put a link down below, but go over to Forensic's channel if you want a more analytical view of what videos are available and where they take everybody. So having said that, I'll say my usual: please be kind, be respectful, whether you're in the grocery store or the gas station. You don't know what the other guy is going through. We want you to comment down below, but please, we don't care if you disagree with us. A lot of people disagree with us, but don't personalize it. Don't be the guy that says, how can you call yourself an attorney and you think... Hey, so anyhow, have a great week, everybody.
Okay.
You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And that's that.
And that's that.
And that's that. Bang.
Okay. No tunnels this week.
No, I'm staying out of the tunnels this week. I
I
was in the tunnels last week.
I think the tunnels have gone into the background. I mean, that one
Thank
crazy.
God.
What?
Thank God that they've gone into the background.
I mean, they're totally irrelevant, but that one guy, that just shows how, I don't want to use the word incestuous, but how copycatting some people that do this are.
Yeah.
One person mentions tunnels, and for about a month, everybody's, oh, there's tunnels. No, there's no tunnels. Yo, we have a map here. Here's the map of the steam tunnels in Moscow, Idaho.
And then it became the secret door that came out of the tunnels inside the house, and everyone loved that, and they ran off with that.
Oh, the secret door. Yeah. And then when they knocked the place down, there was a shadow. It was early in the morning and the sun was just coming up, and there was a shadow, and somebody said, see, there's proof. It's a tunnel. And no, it was a shadow. It was a shadow. So, all right. So we're all done with tunnels. Okay. So